As of mid-2026, the massive artificial intelligence industry is deeply entangled in more than 70 active, high-stakes copyright lawsuits. The plaintiffs driving these cases represent a broad cross-section of global media, from the world's largest newspaper conglomerates to major record labels. The financial stakes are significant, with total claim damages across these various dockets now exceeding $50 billion. Despite these numbers, the legal landscape is fragmented. While some federal courts are granting AI companies full summary judgments, others are seeing those same companies pay out historic billion-dollar settlements. To understand these conflicting outcomes, we have to look past the broad question of whether AI is fair use. The courts are instead partitioning AI into a three-part technical architecture: data acquisition, model training, and generation. Judges are evaluating the question of copyright infringement separately for each of these technical phases. Whether an AI developer wins or loses depends entirely on where in this three-part pipeline the alleged copying occurred. The most immediate risk is in Phase 1, data acquisition. To build their initial models, many AI companies relied on shadow libraries, unlicensed repositories containing millions of pirated books and articles. In the Bartz v. Anthropic case, the court provided a clear limit to fair use. The judge ruled that pirating books to create a permanent central training library is not a protected activity. That ruling changed the math of the case. Under U.S. law, willful infringement can carry a maximum statutory penalty of $150,000 per work. For the nearly 500,000 books in this dataset, the theoretical liability reached $72 billion. Facing these figures, Anthropic agreed to a $1.5 billion settlement and the mandatory destruction of the unlicensed datasets. Sourcing data illegally removes the standard fair use defense before training even begins. It shifts the case from a technical debate into a dispute over unlicensed property, where the financial risks are much higher. The legal status shifts as we move to the second phase, the actual training of the model. This phase is governed by Section 107 of the U.S. Copyright Act, specifically Factor 1, which asks if the use of the work is transformative. AI developers argue that training is transformative because it converts creative expression into mathematical weights and statistical patterns for a new kind of tool. Plaintiffs are countering this by focusing on Factor 4, the effect of the use on the potential market for the original work. This has led to the market dilution theory. It argues that AI training harms creators by flooding the market with synthetic works that act as a substitute for human labor. This argument was central to the case of Thomson Reuters versus Ross Intelligence. The judge ruled against the AI developer because their system was trained specifically to replace a human-curated legal research tool. The Third Circuit is currently reviewing that decision, which will likely produce the first binding appellate precedent on AI training in the United States. The legality of this training phase depends on how a specific court views the result. Is it a transformative back-end technology, or is it a tool built to replace the people who provided the data? We can see how specific these rulings are in the case of Kadri v. Meta. Here, the developer successfully won a summary judgment for training their Llama model on unlicensed books. Meta won despite evidence that top executives had approved the use of torrented material for training. The reason for the win was technical. The plaintiffs failed to build a factual record that proved the AI had caused specific economic harm to their market. Even so, the judge cautioned that finding in favor of the developer might be in significant tension with reality. These early victories for AI companies are often based on the specific evidence presented in court, rather than a broad legal mandate that training is always fair use. The final phase is generation and output, which carries its own set of legal risks. The most significant problem is memorization, the tendency for a model to regurgitate its source material verbatim. Memorization is a central issue in the New York Times lawsuit, which is currently moving toward trial as part of a larger consolidated case against OpenAI. The judge in that case allowed output claims to proceed because ChatGPT's summaries of George R. Martin's work were found to be substantially similar to the original books. Courts in Europe have taken an even stricter stance. In Germany, the Munich Regional Court recently ruled against OpenAI in a suit involving song lyrics. The court found that simply storing lyrics within the model's parameters is an act of unauthorized reproduction. While the act of training remains a matter of debate, The verbatim output of copyrighted material creates a clear path to liability in both US and European courts. Despite these active cases, the federal government and the Supreme Court have not yet provided a final answer on the fair use question. AI developers are unwilling to bet their long-term operations on a multi-year court battle. To manage this risk, they are bypassing the courts and building a pay-to-train economy, which now generates an estimated $800 million a year in licensing fees. OpenAI has been the most aggressive in this space, recently signing a content deal with News Corp that could be worth over $250 million. News Corp CEO described the deal as an historic agreement that sets a new standard for the value of digital content. Reddit has followed a similar path, signing licensing agreements with both Google and OpenAI worth approximately $130 million annually. Even music labels are beginning to settle their lawsuits in exchange for royalty rates based on how often an AI generates music using their catalog. This move toward licensing proves that AI developers view data acquisition without permission as a financial risk too large to ignore. New technical standards are also appearing, designed to enforce these licensing agreements at the network level. The RSL 1.0 protocol is a machine-readable layer that allows publishers to set granular fees for AI training. It can hard-block unauthorized crawlers and automate pay-per-inference systems. For AI developers, the directive is clear. They must verify the legal provenance of their data and move away from unlicensed libraries. They must also engineer stronger guardrails into their final models to filter out verbatim copies before they reach a user. For content creators, immediate copyright registration provides the legal leverage of statutory damages, which remains the most significant tool for forcing a settlement. The AI copyright wars will likely not be settled by a single court ruling, but by an engineered compromise between the companies building the models and the creators who provide the data.